Part of our commitment to putting Southeast Texas first means getting answers to your legal questions. On Wednesday afternoons, we get to ask the judge. And this afternoon, we are joined by Judge Courtney Arkeen from the courthouse there in Orange County. Judge, it's good to see you.
Good to see you too, Jordan. Thanks for having me.
I was going to say thanks for making time for us. Hopefully it's finally warming up there as well, and we can move on from winter.
I know, a little bit.
Little bit. All right, this first question from a 12 News viewer who wants to know, is it legal to put a lien on a car that was gift transferred, saying he was given a car when he turned 18 and stepfather placed a lien on the title? How does he get that lien removed if there's no record of anything being owed for the gift?
So it sounds to me like it truly wasn't a gift in the normal sense of the word, but people can put liens on vehicles if they are owed some sort of money or sum of money. They have to make application with the Texas Department of Motor Vehicles and sometimes provide documentation to support that. Once the lien is placed, the only way it can be removed is to have that person sign a release of lien. So if he can get him to sign the release, submit that to the Texas Department of Motor Vehicles, then they could issue a new title with no lien.
Okay, so there's a little bit of paperwork that needs to be accomplished, filled out.
Yes, definitely. And that was a real simplistic answer to that question. There could be some other issues that are going on, but the bottom line is if you have a lien on your title, you need to get a release of lien to get that removed.
Okay, good to know. This second question also involves the idea of gifts and inheritance. This person said, my husband inherited a tract of land after his grandfather died. Our attorney tells us the land automatically belongs to my husband and not me. Is this true? I thought Texas had community property. She says, is there anything I could do to be added as an owner of the property?
So the short answer is yes, this is true. So property that's inherited or gifted to someone or they had before the marriage is their separate property. Texas is a community property state, but community property is property that is accumulated during the marriage, okay? So those are very, again, simplistic definitions of those two terms. There are whole semesters in law school just on property, but yes, if it's inherited, it's separate property. Now, he can gift deed her 1/2 of that property to put her on the deed. So he would have to voluntarily gift her a portion to make it property that she owns.
Is there an assumption that, that inheritance sort of takes precedence here if it's one of your loved ones who leaves you the land, or could, I guess what I'm saying is there an assumption that it only goes to you or your spouse, depending on how inheritance works? Is that what kind of
there's a general assumption there. There's also been some case law, like if you're going to get married and you get a wedding gift and it comes from your side of the family, typically that's going to be awarded to you if the marriage doesn't go forward. So, there's some thought there, but the black letter law is if it's inherited by you, it's separate.
Okay. Quick time for our final question. This person said, I was recently involved in a car crash. My injuries aren't that bad, but my car was totaled, got hit from behind, and I'm considering hiring an attorney. How would I have to, or how long would I have to pursue any legal action?
Quick answer, 2 years from the date of the accident, you have to file suit.
2 years. Okay, so
2
you've got
years.
a little while to work through that.
Yes.
All right, Judge, it's great to see you this afternoon. Thank you for making time for us.
Absolutely. Thank you.
All right, and if you've got questions for our Ask the Judge segment, you can go to 12newsnow.com/askthejudge, and we'll ask some of those questions next week at 5 o'clock right here on 12 News.